We are on the record in file 24-21841-FC, People of State of Michigan versus Dale Warner. We are here today for hearing on several motions. We are proceeding today partially by Zoom and partially by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Rice.
Good morning, Your Honor. Jackie Wise and Dave McCurdy on behalf of the people.
Good morning, Your Honor. Mary Chartier on behalf of Dale Warner, who is appearing via Zoom.
All right. Sean Head also appearing on behalf of Dale Warner.
Thank you. And these are defense motions, and so Ms. Chartier, I'll let you choose whatever you wish to proceed is fine.
Thank you. Would the court prefer that I address all 5 motions and then the government respond and then I respond, or would the court prefer we just do one at a time?
I would rather go one by one.
Thank you. I'm going to start with what is a fairly straightforward one, and that is the motion regarding business record certifications. The reason that I filed that motion is because I want to avoid the last-minute scramble, which almost inevitably happens when there are a number of business records that may be admitted. The Michigan Rule of Evidence only mentions reasonable notice on behalf of a party who intends to use a business record certification rather than have the custodian of records come in. But there's no indication what reasonable notice is. So reasonable notice to a party could be 2 days, it could be 2 weeks, it could be 2 months. The court has the authority to set a scheduling order, and the court actually has set a scheduling order with deadlines in it. I am well aware that there will likely be a new scheduling order coming, given that the trial date is being moved because of a medical reason that I have from September to January. And I would ask that when the court issues a new scheduling order, it include a date in there for both parties if they intend to use a business record certification to notify the other side. The problem with not having a date in a scheduling order is that, again, we may get notice, for example, from the government 2 days before that they intend to use 10 business record certifications. Then, if we object to those, we have to file an objection, state our reasons why, come into the court, litigate it in front of Your Honor. If the court deems that the business record certification is not enough and the custodian of records needs to come in, then parties need to scramble to get those witnesses in. Frequently with business records, those parties may be out of state. There may be a witness in California, Minnesota. I mean, they've come in all over to authenticate business records. It just facilitates a more streamlined, organized method to go forward with trial. And that's the reason that we are asking the court to set a reasonable notice cutoff date for business record certifications. Of course, if something comes up afterwards, one of the parties can certainly reach out to the other and indicate, for example, that they're seeking to do that, use a business record. The court can again address that with the same way that it would address the amendment of a witness list that's late. It would be by leave of the court, but it would be imposed on both parties and it would facilitate a much more organized and streamlined trial process. Thank you.
What amount of time is reasonable in your opinion?
In my opinion, witness lists come in 28 days before, and I think 28 days to me would be reasonable on both sides. That way parties would have ample opportunity to prep their case. Frequently what happens is there may not be an objection, but I've been in a lot of trials when there is an objection. So if someone seeks to use, for example, 5 business records, we may be objecting to 2 of them because we have questions, for example, about the methodology that OnStar records are kept, or the methodology for cell phone records, or whatever it might be. And it's only because of experience that I know that frequently someone is saying, well, now I've got to bring this person in from Minnesota or California, and it's the last minute. And I'm thinking, well, if you had told me 2 months ago that you wanted to do this, we could have resolved it earlier, and you would know that you have to bring that witness in. So I think 28 days in line with when witness lists or final witness lists are due, I think is reasonable notice, gives us ample opportunity to get in front of the court if we object to some of those. Likewise, if the prosecutor objects as well. Thank you.
We have no objection to the court adding something to a scheduling order, which would be appropriate, because I agree that if we need to get somebody here, we need the time. We don't want to waste anybody's time, or I also agree that many of those witnesses do come from out of state. We want to make sure that we're ready and prepared to go. I just believe I would ask you to deny the motion as it's written because I don't think it's appropriate to order the people to do that. However, adding it to the scheduling order, we have no objection.
Okay, I think that adding a deadline for this kind of notice is reasonable, and it promotes the early resolution of issues and makes for a more efficient trial. So I think that a 28-day period is completely appropriate. It sounds as though people agree with that. So I would include that in a revised scheduling order that both parties notify the other of any, or identify their business records that they intend to admit through the certification process at least 28 days before the trial date.
To be clear, Your Honor, is that formal notice? So for example, by that I mean it's not just me sending 1,000 documents to the government and then them having me guess which ones I intend to use, but me providing notice that I would like to use business record certification on X, Y, and Z, and then that puts them on notice of that? Is that I just want to make sure I understand the notice requirement.
I'm not certain I understand the distinction you're drawing. So I envision a notice that says, here are the records that I intend to admit through the certification process, and here's the certification.
So that's correct. That's the way I envision notice rather than just, so for example, we've gotten a lot of business record certifications already throughout the entirety of this process, but we don't know which ones the government is seeking to admit. And the reason that I'm asking that question is because there's a Michigan Court of Appeals case called People versus Dingy, which is actually up on appeal at the Michigan Supreme Court now, where the lines appear to be blurred. There was no formal notice in that case, but the appellate court said, well, you had the records and you had the certification, so you should have gleaned from the prosecutor's proofs at the exam that they were going to intend to use this without a business record custodian. I think that is contrary to the rule of evidence. I mean, the rule of evidence is pretty explicit on that, but I just wanted to make sure that the notice that the court is requiring us to provide is formal notice just with, I intend to use it for 1, 2, 3.
I'm envisioning something like a witness list that has that information that Ms. Wise has said.
That's correct. So typically when we send a request for records, we get them through search warrants or whatever, we get that certification of business records along with them. We decide prior to trial whether we're going to use that certification and provide notice to the court as well as defendants. So that's what we fully intend to do.
It sounds like we're on the same page.
Perfect, thank you. Always nice to start off one motion where the parties agree. I don't know that that will continue on with the remaining form. The next one I would ask for is the motion to compel discovery, and I would ask that the court grant that. The defense is missing discovery that's critical to Mr. Warner's constitutional rights, and the government has to turn over evidence that's in their possession, but broader than that, evidence that is in the possession of the police. And where this is coming up appears to be twofold right now. Text messages that law enforcement has engaged in with various individuals related to this case. There may be emails as well, I don't know. But also a lack of notes or documentation of witness interviews. So we received, after this motion was filed, roughly 15 pages of text messages between Detective Drew York and Greg Hardy. And we received, I believe, 5 pages of text messages between TJ Bach, who is Mrs. Warner's son, and Detective Drew York. These are clearly not complete messages. You can tell by the context of the messages. Also, a police report references that Greg Hardy revoked consent to view a USB device that he had provided to the police or that had been provided to the police either by Mr. Hardy or a private investigator. And he did that via text message. We don't have that text message. So they have provided 5 pages with TJ Bach and 15 with Greg Hardy, but they're not complete. And they need to be complete. It's not enough for the government to just say, well, we're turning over what we have for witnesses we intend to call. The court rule does require that written or recorded statements, a text message, an email would be a written statement pertaining to the case by a lay witness, all of whom these individuals are, that a party may call at trial be turned over, and that's supposed to be turned over 21 days according to the Michigan court rules. These messages were from far longer back than 21 days. And again, we only have a portion of it. The significance of those messages, though, is clear, and it will be clear, at least as it relates to Greg Hardy, when I get to the motion related to the search warrant. Mr. Hardy makes statements in those text messages, one of which is contrary to what is in the search warrant affidavit. The detective responds to Mr. Hardy related to something else, but talks about the fact that Mr. Hardy has made comments to the media that are not accurate about the tank. So getting these messages is critical to Mr. Warner's defense, because not only are they Brady material, but they also relate to impeachment under People versus Grissom. If Greg Hardy is making statements to the media, which the detective is saying are not accurate, we need that in order to cross-examine Mr. Hardy at trial. And even though the government may say, well, listen, we've provided information for witnesses we intend to call, we may call other witnesses. So they don't get to gatekeep the information that they have, and they don't get to gatekeep the information that the police give to them. If the police have it, the case law is abundantly clear. If the police have it, it has to be turned over. The government can't say we don't have it, the police have it. If the police have it, it has to be turned over. And so it is also clear when the government responds and says, well, we've turned over all the notes that police officers have. It seems highly unlikely that that's accurate. Again, they may have turned over all the notes that they have, but it seems highly unusual that the police would be taking no notes of supposed conversations that they have with witnesses. So there is not video or audio or police report referencing claims supposedly made by Greg Hardy related to this tank. And so if the government is really and truly claiming that they have turned over everything they have, I think that we need to have a hearing and put the detective on to see, has he turned over everything to the government? And if he is claiming that he has, why do we only have partial text messages? And especially, again, as it relates to Mr. Hardy. If messages were deleted, I think that we have a really great forensic unit in the state who can look at the phone and retrieve deleted messages, and that's through the Michigan State Police. So just because someone may have deleted messages does not mean that they are no longer available. And if messages were deleted by the police, I think that they have to respond as to why that was done, because that would be the destruction of evidence. And if messages were deleted, then we are entitled potentially to a jury instruction related to the destruction of evidence. So there are a lot of questions here that remain unanswered. The government's response is essentially 2 lines. We've turned over everything that we have that we intend to use for witnesses. Again, that cannot be accurate just based on the context of these messages, which we received after we filed our motion, and the police have turned over all their notes. They really, it appears that would be highly unlikely, because references to a now critical piece of evidence are not mentioned as it relates to Greg Hardy earlier than August of 2024. And if they are mentioned somewhere, we don't have that. So I would ask the court to order the government to turn over this information. And given the fact that they are saying we have turned over everything we have, I would now ask the court to order a hearing where we can talk to the detective and try to get to the bottom of what is missing and why it's missing. Thank you.
Your Honor, we have turned over everything. I don't know the statement that all the text messages are not complete. I don't know that that's accurate. We have, Detective Junior has turned over all of the text messages he has with the witnesses in this matter. As far as a text message discussing Greg Hardy's revoking consent to search a thumb drive, that was described in a report dated October 13th, 2022, over a full year before this case was charged. The officer details the conversation he has with Greg Hardy, going to the house, doing all of those things. That trooper no longer works with the Michigan State Police. Those are no longer available. He detailed it, and as far as written notes and communications, I've reached out to Detective Sergeant Dreer. They have turned over everything that they have. Yes, we didn't have the text messages. We didn't realize that those were part of the request for discovery at that time. However, everything else he has confirmed with me has been turned over. That was turned over previously, the over 10 terabytes of information in this matter. So we have nothing in our possession. Michigan State Police has nothing in their possession left to turn over, Your Honor.
I guess Ms. Wise, so there is a text message somewhere between Mr. Hardy and the police that the police no longer have.
From 2022, that is correct.
I appreciate it was a long time ago, but it was a text with a person involved as a witness in this case
Correct.
that they no longer have.
Correct.
Okay. I think based on that, it is reasonable to give the defense an opportunity to have a hearing and investigate the possibility of whether or not there is other information that was collected or communications that were exchanged that the police no longer have, and what the reasons may be for the police no longer having that. And so I would grant at this point that request. I think that's as far as I can rule on this motion at this time until we have some additional information about what, if anything, else may be missing and the reasons for it. So I would grant the request for a hearing, and we can schedule that.
Thank you, Your Honor. Next up would be the motion to suppress the findings of 2 search warrants, or alternatively for a Frank's hearing. I've never been a judge, but I think it would be difficult to decide to suppress evidence when you have the parties saying different things. So for example, the defense is pointing out inconsistencies, misleading statements, false statements in affidavits, and the government is saying no, they're not. And so for that reason, I would request to have a hearing, because the 2 search warrants at issue in this case are based on affidavits that contain false statements. And as such, I made an offer of proof in the brief, but with the additional text messages that we received, I can make even further an offer of proof. So Mr. Warner, as the court is well aware, is entitled to an evidentiary hearing to attack the veracity of a warrant affidavit when we show that there is a substantial preliminary showing that the detective allegedly acted with either deliberate falsehood or with a reckless disregard for the truth. One of the most significant things as we look at the 2 search warrants, one for the tank and then one for fingerprints, is the detective's recitation of what he says Greg Hardy and Parker Hardy said. So in that specific search warrant affidavit, number 8, the detective says that both Parker and Greg stated that they observed an old and rusted anhydrous tank in the wet chemical barn at the Munger Road farm during the week of Dee's disappearance, and in parentheses, it says 4/25/21. Both Parker and Greg stated that Dale was painting / refinishing the anhydrous tank inside of the chemical barn. In the text messages that were disclosed after this motion was filed, Greg Hardy texts the detective, the same detective who wrote this affidavit, and says, obviously, I have not seen the tank personally. That undercuts the statement in the affidavit that Greg Hardy supposedly saw this tank. Then the detective also states in his message to Mr. Hardy later on, what you have said in the media about the tank and the circumstances surrounding it are not accurate. That is significant because Greg Hardy has claimed that he talked about the tank to the police early on. But that does not pop up in any interview, any report. We don't have notes, but if we did have notes, I don't think it would even be in there. So this only really comes up when the detective writes this affidavit about Greg Hardy supposedly talking to him about the tank. But it is in contrast to Greg Hardy's own statement in the text messages, as well as the detective's comment to Greg Hardy, who's making claims to the media that he talked about the tank early on in this process, that what he's saying to the media is not accurate. That should be explored in a Franks hearing. The other matter is Parker Hardy. So Parker Hardy does not say that he saw Mr. Warner painting and refinishing the anhydrous tank inside of the chemical barn. He said he saw a tank inside of the chemical barn, and Mr. Warner supposedly told him that he was painting it and redoing it. But what's significant, not only with that vast difference, is the government has had, and by the government I mean the prosecutor, but the detective who wrote this affidavit, has had access to the surveillance videos that were on the farm. I would like to cross-examine the detective and have him show me exactly where that week he supposedly has Mr. Warner in the wet chemical barn with a tank with Parker Hardy walking in. Likewise, where in that week is Mr. Hardy in the wet chemical barn with a tank and Greg Hardy walks in? I don't think he's going to be able to point to that in the video because we have not seen it and we have looked at it multiple times. So there is, at the very least, a reckless disregard for the truth. And at best, I think, or at worst, I should say, knowingly misleading statements in the affidavit. Likewise, when we get to the affidavit for fingerprints, which was in December of 2024, the affidavit has a very critical reference in number 18, that Mr. Warner was alone on the farm on April 25th, 2021. That's patently false when you look at the video. There are people all over the farm, including Mrs. Warner's children, workers at the farm, Mrs. Warner's nephew, Mrs. Warner's sister-in-law. There are people all over the farm. So to claim to a judge that Mr. Warner was alone on the farm, and the belief is that by 6:40 p.m. on April 25th, 2021, the tank had been cut open, Mrs. Warner put inside, the tank welded back shut, painted, put back out. It is belied by the surveillance video that the detective has had and purportedly viewed. It is just not supported by that. There is no period of time where he is alone on that farm where he could engage in this activity. Are there moments that no one else is on the farm? Yes, brief periods of time. Not long enough for this to happen, and certainly that is not referenced when the statement says he is alone on the farm. There is no mention of the well over a dozen other people who are on that farm. Moreover, the detective states that one can see a non-manufactured well on Deputy Greca's body cam and that the weld in question is consistent with the weld on the tank that was seized. I'd like to ask him about that because I viewed Detective Greca's body cam multiple times, as have numerous people in the office. I'd like to try and figure out what he is claiming to be a non-manufactured weld that is consistent with the non-manufactured weld in the tank at issue in this case. I don't see it from the video. And the other thing is, in the video where the government is questioning or the detectives are questioning their welding expert, they ask him about enhanced photographs that they have and whether that expert would be able to opine on whether they're consistent. We have no report indicating that he can do that. He doesn't say that he can do that on any sort of audio or video. There's no police report indicating that he somehow looked at these two welds and determined that they were consistent with one another, which I think speaks to the fact that the detective can't make that claim. If a welding expert can't make that claim, the detective can't make that claim. So what we have here are two affidavits for search warrants where the statements made by Parker Hardy are inaccurate. Statements made by Greg Hardy are not supported by any documentation in any report or any video that we have. They are directly contrary to a text message that Mr. Hardy sent. The detective indicates that claims that Mr. Hardy had made to the media are not accurate. And we have an allegation of a non-manufactured weld, which does not appear to be supported by the welding expert who the police used. And more significantly, and even most significantly, a claim that Mr. Warner was alone on the farm on April 25th, 2021, which is not accurate. The statement in the affidavit is not that he was alone in a barn, alone in his house, alone. It is that he is alone on the farm, which is inaccurate. And so while I certainly would like the court to suppress the evidence obtained via both search warrants, I understand the difficult position that the court is placed in, because you are going to hear a very contrary interpretation of the affidavits from the government, and then I will be able to respond. So at the very least, I would ask for a Franks hearing, which can be coupled with the hearing on the discovery that the court has already ordered. Thank you.
Your Honor, as it relates to Exhibit A, the statement, Greg Hardy never made a statement to Detective Dreher because they don't have it on body camera, they don't have any of those items, does not amount to a false statement. Now, Ms. Chartier gives you some examples of text messages. There's no indication that those are even the two same tanks that are being discussed within that conversation. As well as any media, there are other tanks on the farm, there are other tanks being discussed, the old anhydrous tank versus the tank that Dee's body was welded in. And Detective Dreher tells Greg Hardy that he made some false statements to the media regarding the tank. Yet he doesn't discuss what those statements to the media were during that conversation. Detective Dreher did not make any false statement within this report. And there is no false statement. They also claim they don't like the way that it was worded, saying that Parker and Greg stated Dale was painting, refinishing the tank, versus Dale stated he was painting and refinishing the tank. Again, alleging they don't like the way they worded something does not equal a false statement. None of these statements are false or misleading. And Franks tells us that you cannot hold a hearing just for the sole purpose of cross-examining the officer. You have to show a false or misleading statement. Neither one of those are false or misleading, and there has not been a substantial showing that there was. They also allege that Parker Hardy made some statements that were omitted from the search warrant affidavit that should have been in there. However, even if we strike those statements or add the omitted statement, this Exhibit A contains sufficient probable cause to authorize that search warrant for that property for those tanks, Your Honor. As to Exhibit B, defendant finds fault with the wording, again, on the definition of alone. Alone is defined as separated from others and isolated. The search warrant affidavit indicates that Dale Warner was alone on the farm while he was gathering those items necessary to cut open and weld the tank shut, meaning he doesn't have other people with him when he's gathering the cutting wheel. He doesn't have other people with him when he's gathering the welding equipment and going into the barn. So that is, again, not a false statement by Detective Dreher. Probable cause, you must look at the life cycle of the evidence sought, and given the totality of the circumstances, which includes the criminal, the thing to be seized, the place to be searched, and most significantly, the character of the criminal activities under investigation when looking at this. And again, let's look at Exhibit A, Your Honor. Again, if we strike the statement, Dee Warner is reported missing on 4/25/2021 from her residence where she was last seen. She was bound over to this court on June 2024 on charges of open murder for Dee Warner, which means either they waived a probable cause hearing or a court found probable cause to believe that Dale murdered his wife. Defendant moved an anhydrous ammonia tank after revoking consent to search the Munger Road farm and asking Detective Breck to leave the property on 4/27/21. Defendant was searching for something near the welding equipment on the evening of 4/25. There were several tanks owned on the properties of the defendant. If you strike Greg Hardy from giving the statement, during the week of Dee's disappearance, Dale stated he was painting and refinishing a tank in the wet chemical barn. This tank does not appear to be cut open or welded at the time Parker observed it. That is adding the omission and putting in that Dale stated he was painting the tank. There was welding and other equipment located on the Munger farm during the week Dee went missing, which could be used to alter the tanks to store human remains and other evidence of homicide. Based on Detective Dreer's training and experience, defendant searching for the welding equipment and later moving and altering the physical appearance of a tank during that week, it's probable that alterations were made to anhydrous tanks during the week of her murder. It's clear that he made that plural, that Dale Warner was altering tanks during that week. Again, as to Exhibit B, there is sufficient, there is no false statement. Again, I'm just going to repeat that. However, striking any of those statements, this court would have sufficient probable cause to sign Exhibit B. Dee Warner was reported missing. The defendant was bound over. Defendant moved an anhydrous ammonia tank after revoking consent to search of the Munger Road farm and asking Detective Greg to leave his property on the 27th. Defendant was searching for something near the welding equipment on the evening of 4/25/2021. Affiant seized an anhydrous ammonia tank from one of the Warner properties on 8/16/2024 during the execution of a search warrant, which was x-rayed and revealed human remains inside. It was confirmed that the remains were those of Dee Warner. The lab collected labels that were affixed to the exterior of the tank, which had fingerprints on the sticky side. Again, there is sufficient probable cause within that search warrant affidavit striking out the items that they claim are false and misleading. There is no sufficient basis for a Frank's hearing, Your Honor.
The government claims that we don't like the wording of the affidavit. The reason we don't like the wording of the affidavit is that it's false. So let's start with the second one. To make a claim that Dale Warner is alone on the farm and is gathering in nearby several items that would be necessary to cut open, weld, shut, and paint the anhydrous tank. That's the statement made by the detective. It doesn't say he was alone in the barn. It says he was alone on the farm, which is absolutely false. And that's why we wanted to be able to cross-examine Detective Dreer. Why did he make that false statement? Because if he had put in there all the people who were on the farm and all the times that they were on the farm, I cannot see a district judge signing this. Because the argument that he would have done all this and been able to do all this, move a tank, cut it open, put a body inside, weld it shut, paint it, put a label on it, move it again, with all those people on the farm on April 25th. It just is not logical. Because it didn't happen. These are not small tanks. These are tanks that weigh thousands of pounds. This does not happen in a matter of minutes. It happens in hours and hours and hours. And what do we know from Parker Hardy's interview? That when he saw the tank, it had a factory weld on it. So the tank that he is talking about, the tank seems to be an issue that he says he saw days after April 25th, that week, had a factory weld on it, which is directly contradictory to the government's now stated timeline in the affidavit that everything was done by 6:40 p.m. on April 25th. I think that the detective didn't include all the people who were on the farm, because a judge would say, wait a minute, how are you claiming these two things going on concurrently on that date? It's not that this is miswording a statement. It is blatantly ignores what the surveillance videos show and what the police have had access to for years. It is not just negligent wording. It goes far beyond that. The detective knew full well that Mr. Warner was not alone on that farm on April 25th, 2021, and did not put that in the affidavit but then specifically put in a falsehood that he was alone on the farm. As to the first affidavit, again, these are not wording issues. It says that both Parker and Greg stated that they observed an old and rusted anhydrous tank. What, again, Parker Hardy said was the tank had a factory weld on it. Again, that was omitted. And these words were carefully chosen to omit information that the government did not want a district court judge to hear, and phrased in such a way that it is a falsehood. The tank in the barn, again, Detective Drury should be made to show, if you are going to make this claim, and we have surveillance video from that week, show us. Show us where Mr. Warner is in that barn with Parker Hardy, and where Mr. Warner is in that barn with Greg Hardy, where he supposedly makes the statement. I don't think he can do it because it's not there. And for that reason, I request a Frank's hearing.
Right, if false statements are made in an affidavit in support of a search warrant, evidence obtained pursuant to that warrant must be suppressed if false information was necessary to a finding of probable cause. In this case, the information the defendant argues was false, was not, in my opinion, necessary to the finding of probable cause. Stated another way, even without the alleged false statements, the affidavit contains sufficient information to establish probable cause to do a visual inspection of the exterior of the anhydrous ammonia tank and for fingerprints. If we omit the statements that the defense has argued are false, if we assume for the sake of argument that they are false, I believe the magistrate still had information that that would support the finding of probable cause, and that is that the magistrate had information that Dee Warner was reported missing on April 25th, 2001. I'm sorry, 2000. Got the year wrong. I apologize. 21. No evidence showing her location had been discovered. Dee Warner was last seen at her residence, the Munger Road property. Video footage from that day, from the day that Dee Warner was reported missing, shows Dale Warner searching for something near the welding equipment in the old shop on the Munger Road farm, and that there was video footage of Dale Warner moving an anhydrous ammonia tank from the Munger Road property to the wet chemical barn on April 27, 2021, after having revoked consent to search the Munger Road home property on the same day. The magistrate would also have the information that Dale Warner had been charged with Dee Warner's murder and had been bound over to the circuit court on that murder charge, and that alterations to an anhydrous ammonia tank could allow for the storage of human remains or other evidence of a murder. I think this information alone, again, without the statements argued by defense today, is sufficient for finding probable cause, the information alone constitutes a substantial basis for inferring a fair probability that the evidence of a crime would be found in a particular case, which is the standard that the magistrate uses to determine whether a warrant is appropriate. And so for that reason, I would deny the motion to suppress.
Thank you, Your Honor. Jail calls I'd like to discuss now. So this is a novel issue. I don't know if it's come up, but in general, when jail calls are an aspect of a motion to suppress, the argument has been that the jail does not have the authority to record the calls. We're not arguing that at all. The jail absolutely has the authority to take reasonable actions for security in the jail, and recording phone calls and listening to them is reasonable because it relates to jail security. What Mr. Warner is challenging is the prosecutor and the police's ability to listen to these calls seemingly at whim, whenever they choose, without a warrant, and then handpick what they turn over to us and what they intend to use. The government is not all-encompassing when we use that term. The government in a criminal case does not mean jail personnel. So when we're referring to the government in a courtroom, we're referring to the police and the prosecutor related to the case. The government, in this case, the prosecutor, wants to fold the jail in and say, well, we're all part of the same team. So if they have access to it, we have access to it. It's inaccurate. There's no case law to support that. There's no law to support that. The jail has a job to do, a very serious job to do, and they listen to calls because that's what they need to do to ensure security. That does not mean that they can pass those calls along to a member of the public. And that's exactly what the prosecutor and the police are in this case. They're a member of the public. If I called up and said I'd like to listen to Larry Smith's phone calls in the jail, they would laugh at me and then hang up the phone, as they should. It should be the same for the police and the prosecutor on a case. When they request to listen to phone calls, they should be denied unless they have a search warrant that gives them access to those phone calls, which they didn't in this case. And that's the basis of the motion to suppress 2 phone calls that the government has. Now, the equal protection argument is not because Mr. Warner is indigent. It's because Mr. Warner is only in the jail because he cannot afford to make bond. And the reason that that's significant is if Mr. Warner had made bond and he was at home talking to his family or friends or anyone on the phone, the government couldn't just listen to those calls. They would need a wiretapping search warrant to be signed by a judge, and there would be specific parameters of what they can listen to. Those parameters are generally, once you establish that it is with a lawyer, with a doctor, with a clergy member, you have to sign off. And once you establish that the phone call is related to personal matters, usually they're given a specific amount of time you need to reduce or minimize, so you don't listen to the rest of it. They don't even have those parameters because they didn't get a warrant. They're just able to, I guess, sit at their table and eat their lunch and listen to Mr. Warner's phone calls. Mr. Warner is being denied equal protection because the only reason that the government has access to jail calls is because he's in jail and he can't afford bond. A wealthier defendant who was out on bond would not be in the same position. But Mr. Warner, again, also has a privacy right. Now, Fourth Amendment rights are vastly diminished when a person is in custody. There's no doubt about that. But they're not thrown totally out the window. And in this situation, his phone calls, while appropriately listened to by the jail, should not be listened to by the police and the prosecutor. And that is the basis for our motion to suppress those calls. If the court chooses to deny the motion, we would ask for the same access that the government has. If they're allowed to listen to Mr. Warner's calls at whim, we'd like to be able to listen to all of Mr. Warner's calls as well. Because the government is going to try to hand-pick certain statements made in certain calls. And we don't have the aspect to explain contextually where these statements may be coming from. So, again, if the jail wants to monitor jail calls for jail purposes, absolutely within their rights. But they don't get to cede that to the police and prosecutor while they try to build a case against an individual. That absolutely violates Mr. Warner's Fourth Amendment rights as well as his rights to equal protection. Thank you.
So this is a Fourth Amendment issue. The Fourth Amendment protects against unreasonable searches and seizures by the government. It doesn't specify police, although that is obviously the normal way that it would work. But the jail is a government agency, a government entity, and so that by them being a government entity, she's given up the game by saying that it's reasonable for them to monitor and record his calls. I mean, by saying it's reasonable, that means the Fourth Amendment is not implicated when they do so. Because the Fourth Amendment is not implicated, that means that yes, they are accessible to us to review and decide whether any statements he makes are admissible under the party opponent exception to the hearsay rule. So by that alone, you should deny the motion. I'm not going to reiterate what I've said in my brief, but I mean, the case law is also all in our favor when you actually review cases that involve the police and the prosecutor using recorded jail calls at trial. In the cases, I mean, I've cited cases They're mostly federal cases because those are it's been specifically addressed at the federal level. But when it has been addressed in Michigan, the Michigan case law is all on our side that says these are admissible by the prosecution at trial. And I haven't heard anything contrary to that, not a single case. So for those reasons, the Fourth Amendment issue is really a non-starter. In terms of equal protection, what they'd be arguing is that every pretrial detainee, you cannot monitor their calls. The jail cannot monitor their calls. Because by definition, if you're a pretrial detainee, unless you've been remanded, and my experience here is that there are very few, if any, remanded pretrial detainees. They're all there if they have failed to make money bail. That would mean that none of them could have their calls monitored by the jail if this is an equal protection. And again, they've kind of given up the game when they said that it's not because he is poor. Well, that supposedly was the basis of the motion, that we're discriminating against poor people. But that's not the case at all, because a wealthy person could still have a bail set high enough that they can't make it under the Michigan court rules, which expressly prohibit setting bail based on economic status, i.e., denying someone who is poor. So if there's no basis of here that we're discriminating based on someone's lack of funds, then again, there's no equal protection. And I would disagree that there's even an equal protection question to begin with. But even if there is, there's not a violation. So unless the court has any questions, I would stand on our brief.
Sometimes I wonder if I'm in the same courtroom. I thought I said multiple times that the jail absolutely has the right to monitor phone calls at the jail. But the fact that the jail doesn't mean that the police and prosecutor can do it. The fact that they all seemingly work for the government doesn't mean that any government employee can listen to jail phone calls. That is a ludicrous argument. If you think of all the people who work for the government, it could be a trash collector. It could be somebody who works in animal control. It could be the custodian at the courthouse, right? He works or she works for the government. Court personnel work for the government. Their argument is essentially, if you draw a check from the government, you have access to those jail calls. That is fundamentally ludicrous. I never said that the jail can't monitor the calls. But what did the government just say? I said that the jail can't monitor the calls. If the court grants my motion, the jail can't monitor the calls. It is fundamentally the opposite of what I said. The notion that the jail can do it does not mean that anyone who works for the government can do it. If they want to listen to a call, they need to have a search warrant for it. The same way they would need if Mr. Warner or any other person incarcerated at the jail made bond. Never in my motion did I say the government is discriminating against poor people. What I said was people who cannot afford bond for whatever reason should not lose their entire Fourth Amendment protections because the government wants to sit at its whim and listen to their jail calls. Also, what is significant is that not all the case law is on the government side. The cases that have examined this issue have fundamentally done it with, is the jail reasonable in monitoring calls? And we're not arguing that they're not. But in a case that is cited in the government's brief, People versus Tebow, the court held that the defendant's telephone conversation at a police station had been improperly intercepted by an officer who picked up an extension because there was nothing in the record that indicates that the defendant should have known someone was listening. In this case, Mr. Warner, of course, knows that the jail is listening, but there's nothing to inform him that any prosecutor who wants to listen to his calls, or any police officer, or any government employee that the government is arguing can listen to his calls. You are fundamentally cutting off individuals who are incarcerated at the jail from being able to speak to their family. If you say, well, he could just choose not to talk to anybody on the phone. Well, he's in there for months on end. So, of course, anyone in the jail is going to want to have contact with family and friends and loved ones. But the fundamental issue here is he knew the jail would listen. He was not notified and had no reason to believe that the police and prosecutor would listen. And they shouldn't be allowed to listen at their whim. They should have to seek out a warrant, for that information. They are in no different position just because they draw a check from the government than any other member of the public. I can't listen to those calls, but they can because they get a paycheck from taxpayer funds. I don't think that's correct. It's certainly not what the Constitution allows, and I would ask the court to suppress the jail calls. If the court is going to allow the admission of the jail calls, I would ask the court to order that the government turn over all Mr. Warner's jail calls, so they don't get to just pick and choose what they use, that we get to listen to all of them and put any statement that they choose to make in context. We have the right to do so under the rule of completeness, and People versus Warren, we have the right to do so if we believe that other statements would put the statement that the government seeks to admit into context. Thank you.
That his use of the use of the recorded jail calls violates his constitutional rights. However, I don't think that this argument is accurate. First, regarding the Fourth Amendment expectation of privacy standard, which I think is the fundamental issue at play here. The Fourth Amendment protects against unreasonable searches and seizures, but it is only triggered when there's a constitutionally protected reasonable expectation of privacy. In order to establish a Fourth Amendment violation with regard to telephone conversations, the defendant must have a reasonable expectation of privacy in that conversation. As our Michigan Supreme Court has established in People versus Collins, to determine whether a person has a reasonable expectation of privacy, must be determined that the person had a subjective expectation of privacy and whether that expectation was one that society recognizes as reasonable. Furthermore, our Supreme Court has held that what a person knowingly exposes to the public is not subject to Fourth Amendment protections. Here, I don't think defendant can establish either prong of the Collins test. The defendant himself acknowledges in his brief and during argument today that he was on notice that his calls were being recorded. That admission alone destroys any claim to a subjective expectation of privacy. One cannot reasonably expect privacy in communications when explicitly told that those communications are being recorded, monitored, and listened to by another person. Moreover, under the Catania case, by knowingly making calls that he knew were being recorded, Mr. Warner knowingly exposed those conversations to the public, in this case, jail officials and law enforcement. I would make an analogy. Ms. Shardy mentioned trash collectors. When someone puts their trash out at the curb, they can't then complain if someone goes through that trash, picks something out that is embarrassing or criminal and gives it to another person. And that essentially is what I see has happened here. A call was made that was known to be listened to, and that gives up the right of privacy. And so what happens to it after it has become something that's in the public can't be complained about. Assuming for the sake of argument that there was a subjective expectation of privacy, I don't think that it is one that would be objectively reasonable. Even if Mr. Warner believed that his calls were private, I don't think a reasonable person in his position would expect that privacy in jail telephone calls, or that he or she, I don't think that a person in his position would expect privacy in jail telephone calls that he or she knows is being recorded. As the United States Supreme Court stated in Lanza versus New York, it's obvious that a jail shares no attributes of privacy of a home, an automobile, an office, or hotel room. And in prison, official or jail, in this case, official surveillance has traditionally been the order of the day. And so even if Mr. Warner had a subjective belief that he was making a private call, I don't think that's one that would be recognized as objectively reasonable. With respect to the equal protection argument, Mr. Warner raises an equal protection challenge claiming discrimination based on economic status, or I suppose the status of those not being able to make their bail versus those that are able to make their bail. This argument has been addressed by the Michigan Court of Appeals in People versus Good, which is an unpublished per curiam opinion of the Court of Appeals that was issued on October 13th, 2015, docket number 2295538. While that opinion I recognize is not controlling because it is an unpublished opinion, I do find it persuasive and would rule similarly here. That court found that there's no known support for the proposition that the recording of jail calls violates equal protection, and as I said, I find that decision reasoning persuasive and would rule similarly here. I do think that the request to have access to all of Mr. Warner's telephone calls is reasonable in light of the ruling. And so I would agree that the defense should be given access to all of his jail calls and an opportunity to explore whether they have any impact on the context or whether there may be some additional information that would be relevant to any of their defenses that would be in those phone calls. So I would grant that.
Thank you, Your Honor. And then the final motion relates to a change of venue. And the court is well aware of the law as it relates to this matter, so I just want to focus in on the concerns that we have. And it is the extensive media coverage related to this case, coupled with the extensive social media coverage as well. When a lot of the cases have been decided on media coverage and change of venue, it really related to traditional media. Newspapers, television, radio. Social media is relatively new when you look at the history of cases that have interpreted whether there should be a change of venue because of media coverage. And there has been a tremendous amount on social media about this case. All of it, practically all of it, fundamentally against Mr. Warner. Many people have let their emotions really drive their opinions on this. I would gather that most of those folks, if you ask them if they believe in the rule of law, believe in the Constitution, are you law-abiding, they'd probably say yes to all of that. But when you look at what people are saying about Mr. Warner, his trial rights, his constitutional rights, all of that goes out the window. And there is an individual in Lenawee County who posted on the Justice for Dee page about how to essentially be a stealth juror. How to make sure that you scrub your social media so that if you get called for jury duty, no one will ever know that you were on the Justice for Dee page. And that way you can get on the jury and then you want to vote to convict right away. And the frightening thing about that is that this is a citizen of the United States totally flouting the rule of law and Constitution to try to reach an outcome that he wants. But beyond that, not one person commented, "What are you talking about? That's totally antithetical to everything that our country stands for." No one said that. People liked his comment. Not one person said the opposite. Likewise, when a relative of Ms. Warner's made a comment about they could set up an ambush of me, not one person said, "That's wrong. Why on earth are you leaning towards violence against a defense lawyer?" It's normal that people don't like defense lawyers. That is part of the job. It's been going on since the beginning of time, and it'll continue on. It's the fact that nobody had a problem with a statement threatening or indicating a threat of violence. Nobody had a problem with an individual talking about how to get on the jury pool, violate the oath that jurors take when they are to honestly answer questions and then to decide the case based only on the evidence in the courtroom. No one stood up for the rule of law. That's the problem. Emotions have run so high here to convict Mr. Warner that it is likely impossible for him to get a fair trial. because the people making these comments are Lenawee County residents. And the people making these comments are influencing their neighbors, their coworkers, their friends, their family, some of whom will be sitting in this jury box. And when emotions take over, and when people's deep-seated prejudices that stem from those emotions are ruling what they do and how they will decide this case, it is really up to the court to step in and be the voice of the rule of law. Justice isn't served by ignoring the Constitution, and justice isn't served in spite of the Constitution. Justice is only served because of the Constitution. And when members of the public forget that, it is up to the court to remind them of that. And that's what we're asking the court to do, to step in and change venue so that Mr. Warner's constitutional rights can be upheld. And if the court chooses not to do that at this time, recognizing that if a fair jury can't be seated, we would renew our motion, we would ask that the court allow us to explore with the government mechanisms to ensure that there is a fair and impartial jury. And some of those were referenced in the government's brief. Questionnaires, questioning jurors singly, those sorts of things. So if the court again denies this motion currently, I would ask the court to allow us to explore those areas and then to meet with the court to discuss how we can at least try to ensure a fair jury for Mr. Warner. Thank you.
So we are in agreement that there are procedures that could be put in place to ensure a fair and impartial jury. And counsel just mentioned some of those. And so this motion kind of puts the cart before the horse and assumes, based on a few anecdotes, that out of the tens of thousands of potential Lenawee County jurors, that 12 fair and impartial jurors cannot be found. And that's just a leap too far. We have certainly some instances of inappropriate conduct of people that may or may not be in Lenawee County. But in all the high-profile cases that I cited, there were high percentages of jurors that were excluded for bias, in the 30% range sometimes. And still the Court of Appeals, the Michigan Court of Appeals says that's, even if you have 30% biased jurors that you have to kick right off the bat, that leaves enough jury pool members to pick a fair and non-biased jury. So without even trying, this court should not grant the defendant a change of venue when he has not shown, and the burden is on him to show, that a fair panel cannot be seated here in Lenawee County, and he just has failed to do that. And the other thing that bears mentioning is that none of the things that he's talked about are unique to Lenawee County. I mean, Facebook obviously could be accessed in the neighboring county. Extensive media coverage. They haven't pointed to anything that was factually inaccurate or inadmissible evidence that that's going to taint the jury pool. So, if we were to move to Monroe or Hillsdale or any place else, we would be facing the same problem. So for those reasons and all the issues that I raised in my brief, I'd ask the court to deny the motion.
Almost every newscast that has an interview with a family member or friend of Mrs. Warner has inadmissible evidence in there. People are talking about things that's hearsay. Whether or not those items can be admitted at court is something that happens during a trial. And a lot of what has been said to the media would never be allowed in a courtroom. The issue is what Mr. McCready said. There are tens of thousands of jurors, he says, possibly in Lenawee County. There are tens of thousands of people on a social media page where an individual talked about being a stealth juror. So questioning that juror, putting a questionnaire in front of that juror, that's not going to matter because that individual has already said, I'm going to lie. And here's how you can do it too. And the concern is, of those tens of thousands of people, no one stood up for the rule of law, which is why we are asking this court to do so. Thank you.
Right. Obviously, the general rule is that defendants should be tried in the county where the alleged offense was committed. There is an exception to that under the case law. I do share some of the concerns about things that have been said, particularly online in this case. And I think, contrary to what the people have said, I think that it's more than a few anecdotal examples. However, I don't know that at this point it rises to the level for me to say that a fair jury cannot be picked without some further exploration of these issues. I take seriously some of the exhibits that were attached to the motion in reference to some of the things that have happened online, particularly in this case on Facebook. Because I think some of that does have obviously a prejudicial effect. Whether that has infected the entire community to the extent that a fair jury cannot be picked is, I believe, a separate question that, as I said, needs to be investigated further. I understand that some inappropriate things were made, particularly with reference to the example of a person explaining how to scrub their social media account of any references that might exclude them so that they could serve on a jury. It's very problematic. But I don't know that the fact that no one commented on that comment to refute that or explain why it was wrong means that everyone therefore agreed with it. I think that most rational people at this point have come to the conclusion that many Facebook groups are simply echo chambers, and trying to argue with them is a lost cause, and why it would be foolish to subject myself to the kinds of things that would happen if I were to argue the opposite cause, even if appropriate, in such an echo chamber. And I raise that issue to say that I don't think the fact that no one has criticized these objectionable comments means that everyone else therefore has adopted those and takes those as their own position. But I do think, as I said, there's certainly cause for further investigation, more so than in the normal case, to determine whether or not a fair and impartial jury can be picked in Lenawee County. And some of the examples cited in people's brief, I think, are appropriate. I think that an additional questionnaire that would go to the jury pool well in advance of jury selection. We had some conversation about this in the jury room. I have no interest in calling people in for voir dire that are immediately going to be excused for cause because they have a reason to be excused for cause. I think we can do a lot of work with a questionnaire, and if we need to look at individual voir dire jurors, I'm willing to look at that. But I think at this point we need to make further investigation into these issues to determine whether a truly fair and impartial jury can be selected in this case. We did have, again, some discussion about the issue previously, and I think it probably makes the most sense, given the status and where we're going from here, to have an offline discussion of those issues and come up with a game plan about what that process is going to look like. if there's not agreement on it, certainly we can have a hearing and I can make decisions that are necessary in order to come up with what that final plan is going to look like. But I think we'd make more progress more quickly if we have an offline discussion of that first. So I would, at this point, deny the motion to change venue. I would say that is without prejudice at this point, meaning that the defense can raise that issue again in the future when we have, after we've had a chance to do a deeper investigation of the issues. Okay.
That's it, that's all 5. Thank you, Your Honor.
All right. And we've alluded to the issue of the trial schedule. Ms. Sharkey, is there anything you want to say on record at this point, or do you want to wait?
The only thing is, I discussed the matter in chambers, given the fact that I have surgery, that the trial will be moved from September to begin on January 27th. The court did outline the various weeks that we would be in trial in the specific days. I don't know if the court wants me to go through all that, or if the court will put that in its scheduling order.
And Ms. Wise, you indicated people do not have objection. Is that accurate?
Based on the conversation and the reasons for the delay, the people have no objection.
Okay. I think certainly that we can't control medical issues, and we have to address those. And so I think certainly that establishes good cause in this case for the adjournment, although I fully understand that it causes a number of issues for a lot of people. But in my estimation, it's the only fair thing to do given the circumstances. So we did discuss new dates. I will issue a scheduling order that has all of those dates in them, but if the jury selection, as we discussed, would begin on January 27th, and the trial in total would run through March 27th of the dates that we've discussed. And with respect to the particular days, the court will issue a scheduling order that has all those in it. In addition, we'll have that 28-day deadline for the business records notice. Is there anything else that we need to discuss today?
I think the hearing date on the discovery motion, I'll be in contact with your chambers, and I can work with Ms. Wise to make sure that that works for everyone's schedule.
Okay.
Thank you.
Perhaps on that day we can schedule some additional time to discuss the issue regarding potential jurors.
Great, thank you, Your Honor.
Will the court be preparing those orders?
So I'll prepare the scheduling order with respect to the issues, the orders on the other motions. Ms. Sharkey, if you prepare those, I appreciate it.
I will, thank you.
All right, that's all then. We can close the record in this case for today.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.